I'm Michael Scherini, Principal Lawyer of Scherini Lawyers. Today we're unpacking one of the most common legal issues we see across all areas of practice, and that is breach of contract. I'm here with Alan Parkes, Principal Lawyer of Parkes Legal. How you going, Alan?
Good, Michael. I hope you're doing well. Thanks for the introduction. I'm Alan Parkes. I'm the principal solicitor at Parkes Legal. I cover mostly areas in crime, intervention orders, family law, and civil litigation. But this breach of contract issue comes up quite a lot in those four areas.
Yeah,
So, as a lawyer, I need to be on top of it all. And it's quite interesting the amount of times that it comes up.
it's quite a lot of crossover because, quite often you'll have agreements in crime, you'll have agreements in family, whether it's an agreement, might be a private settlement agreement, other kind of binding agreements you might want to tell us about. You might have settlement agreements in criminal matters as well. People quite often don't realise that agreements and contracts, they touch lots of areas, don't they?
Yeah, they definitely do. A good point that you just brought up in family law with binding financial agreements. That's a form of a contract, which not many people are aware of. But it's very important with family law because it can be a bit different to your standard contract or breach of contract law, sorry, with, for instance, buying or selling a property. How important it is, not that it's not important in property law, but how important it is and crucial it is in a binding financial agreement to get that legal advice.
Mm.
Because if you don't get it, it could potentially set the binding financial agreement aside.
That's right, and I think they have a different name for it in different countries. I think people also know it by a different name. What's that name, Alan?
Yeah, so prenuptial agreements, you might have heard in the US, which is
Yeah.
your binding financial agreement. Obviously, when you enter into a relationship with your partner, you want to make sure that your assets are separated from the relationship and you come into an agreement. But yeah, it's usually, your prenuptial agreements or your post-separation agreements, which it can be commonly referred to as well. So you can do them at any time. A lot of people think now we're together, it's too late to enter into a prenuptial agreement. It's not, it's never too late. And in fact, the best binding financial agreement is one which is constantly reviewed every 2 years because circumstances can often change.
That's right. I mean, I work predominantly in commercial litigation, employment, property. I'm on the business side of things mostly these days, but I've done my share of family and crime back in the day, and here and there when I need to do so. And you're quite right. It's effectively a contract's only as good as it's relevant to the circumstances. If people's circumstances change with time, they have children, they buy different assets, the positions change. Sometimes that contract becomes unenforceable, or potentially it's just not as binding. And I think that's, like you said, it's important to review those because a contract is a living document, and the same thing applies to any, whether it's a business terms and conditions, whether it's a binding financial agreement between a relationship. A contract is a living document, and it's not set in stone. It must be constantly reviewed and revised and improved. Isn't that right?
Yeah, you're spot on. And bringing it back to probably an area you're more familiar with, Michael, is the lease agreements between landlords and tenants. And I had a client the other day actually that called me up and needed some legal advice. And essentially, and I won't go through every issue which he brought up, but what's relevant is he was a tenant. He'd been a tenant for about 10 years. He entered into two 5-year commercial lease contracts. Um, and what had happened was at the end of his 10 years, he realised that his bond, which he'd given the landlord to deposit into an interest bearing account 10 years ago, hadn't actually been in an interest bearing account. And he wanted to recoup the interest on that deposit. And the first question I obviously asked him was, why did it wait until 10 years later? Didn't you constantly review the contract to make sure that both of you knew your rights and responsibilities and obligations? And his answer was no. But then when he first came up with, well, there's no issue because I can recoup that interest from 10 years ago. Obviously, you know about statute barred claims. We can't go back more than 6 years, and that started making it a bit difficult.
Yeah. Yeah, that's a Limitations of Actions Act
Yeah.
in Victoria, but and it varies state to state and territory. But 6 years of contract generally in Victoria, and those sorts of things is a great example of being on top of your contracts, revising them, but understanding them. And if you don't understand them, ask your lawyer to explain them to you because that's what we're here for. Quite often you'll get clients that will just say, "Oh, whatever, the lawyer handled that. I don't understand that." No, well, you need to understand it because you can't. You don't want to pay your lawyer every single time you need a clause explained to you. It's going to get very expensive. So make the effort to understand it yourself. It's the same thing when I engage, for example, my IT people. Now they're speaking a different language. I don't understand all of it, but I take the time to understand it because I need to know what is happening with my systems because it's my business. And this is the exact same approach clients need to take when they engage us, right? Is take that practical approach of, well, this will save me costs down the line, and it also help me avoid disputes because I'll understand the terms better, I'll apply them better, and in the context of the business, and then the risk is reduced, and the risk of disputes is reduced significantly.
Yeah. Well, what do you tell clients, Michael, or potential clients that ring up Scherini lawyers and you're giving them advice with respect to a contract? Like, do you inform them about the elements of a breach of contract and what those five elements are?
Well, look, I think before we go back, to that point, I think the first point we need to always go through is assessing whether there's a valid contract. A starting point is to look at the contract, and it's very easy to assume that a contract has come to you is valid, but it's quite important as a lawyer to go through those basic steps of assessing whether or not you've got a legally valid binding contract. And generally the most key elements are there's an offer, a clear promise to do something, acceptance, so that's got to be unequivocal agreement to the offer, consideration, something of value exchange, money, service, etc. Number 4, intention to create legal relations. The parties must intend for the agreement to be legally binding. And number 5, certainty. The terms must be clear enough to be enforced. Now, you work your way through those elements to make sure first that you've got a binding agreement. And it's not until you assess that you should turn your mind to whether or not there's been a breach. And the client will obviously be upset, distressed, and believe so that they've got a case, but it's important to break down a problem in a methodical way and go back to basics.
Correct. And I think amongst those five elements as well, which a lot of people sort of miss, but it does come up. I'm finding it's coming up more often than not in this day and age. But capacity, whether they had the capacity to enter into the contract, and that can be a lot of things, but sometimes it can be age, the age that they entered into a contract, and then also their mental capacity as well. You get a few. I've had a few clients who it's not until you put them in front of a psychologist or psychiatrist who does some tests and they have an IQ level of around 70, but nobody seemed to investigate this before the person entered into a contract. And what that essentially means is sometimes they can have a reading level of about a 5-year-old, but they're entering into a pretty complex contract. So things like that, or whether they even had permission to have authority to sign on behalf of a company. That's another thing to look at.
Yeah, you're right. And look, that can have a big impact on whether there's a legally binding, enforceable agreement, and
Mm.
it can give rise to defences to the other side, and it can also give rise to a whole string of different causes of action, which are beyond today's discussion. But for example, it could give rise to a cause of action for unconscionable conduct. There's a special relationship, the disadvantage there. So it can lead to all sorts of complications, and there's different levels of incapacity. There's incapacity from psychiatric conditions. There's, you could have, for example, someone with dementia, is just completely unable to understand what they're doing. As you said, there could be someone so elderly that their ability to understand is gone. And that's why it's important, as you say. I think that's a great thing that you've raised that where there's doubt, capacity, including when lawyers dealing with your clients, you may as well just ask them to get assessed. And as part of that, there's ways to canvass that carefully with clients. And the number one thing you need to tell clients is that you don't want whatever occurs to be undermined as legally binding, because of the fact that the capacity has come out later, and subsequently been challenged. That could affect all sorts of things. So, whether you're dealing with clients or you're dealing with a client, in whatever industry, not even just legal, you really need to turn your mind to those things.
Yeah, correct. And going back to family law, where I said how important it is to get independent legal advice before you enter into a binding financial agreement.
Yeah.
These are one of the reasons why you get a lawyer to advise you before you enter into that agreement, because part of that checking process by that lawyer should be whether this person has capacity or the mental capacity to enter into this and fully understands what they're entering into. Because with family law, unlike your commercial contracts, with family law, the agreement has to be what we call just and equitable to both parties. It has to be fair. Otherwise, if it was before the Federal Circuit Court and Family Court of Australia, it just wouldn't fly. Whatever agreement you want to enter into, because it has to be fair at the end of the day. The court won't stamp off on it otherwise.
Yeah, and look, and we'll just one final thing on that. It is, it's a court, for example, the family court, where they've got that jurisdiction to make equitable remedies, and setting aside binding financial agreements on just and equitable grounds is quite common, more common than people appreciate. And so, yeah, I do agree with you. I think those documents need to be crafted carefully and revised regularly, to the point that perhaps there's no point having sometimes one at all, depending on your circumstances. It may be relevant at one point in time, it may not be relevant 10 years down the line. But, look, turning to the next topic, let's think about, well, what is a breach, right? And at a very basic level, a breach of contract happens when one party fails to perform or performs poorly, as an example. That could be not delivering goods, paying late, cancelling without proper notice and terminating, doing work that's substandard or incomplete. These are classic examples of breach of contract that very commonly could be summarised as one party just not performing their obligations under an agreement to the other party, and that generally gives rise to causes of action under breach of contract.
Yeah, and also just on that point, with the breach, and if there is a breach, you have to assess, uh, I guess, the category of that breach. So is it a material breach or the failure is so significant that it's causing harm? Or is it minor, which, for instance, delay? A contractor hasn't provided a product to a customer or consumer in a timely fashion, and therefore they can't operate their business accordingly. Are there substantial delays? Is there some sort of integrity issue with the product that's been provided? Or, anticipatory as well, whether one party, after entering into the contract, say, look, I'm not going to be doing this from this date, which is a clear breach, which is going to occur in the future. So these sorts of things as well. We also, as lawyers, have to itemise that to see what the exact breach is.
Look, you're quite right. Effectively, not all breaches are equal. You classify them differently. Some would entitle you to terminate. Some may not be substantial enough to terminate. And this is really where the legal brain comes in. You need to make that assessment on the facts, and each case is different. And you can't say because it happened in one case, it happens in the other. It needs to be assessed case by case carefully, because, deciding to terminate, so for an example, if that was what you wanted to do, I'm not saying you had to, but if that's what you wanted to do, that's something that needs to be decided carefully. Like, we'll give you an example. Let's give you a few examples. There might be something that is a total breach where a party fails to entirely perform the whole contract. Then you might have a partial breach the party performs, but not to the required standard or not as what they promised to do. You might have another example, which you mentioned, Alan, anticipatory breach. One party signals early that they won't comply, which can also, give rise to a breach because they've indicated that positively. And then you've got another common category, which is repudiation. And that's effectively when one party acts in a way that shows they no longer intend to be bound at all by the contract, or they're unwilling to continue the contract. And these are common examples that we see all the time. What about yourself? You've seen these things regularly as well, I imagine.
Yeah, look, I have. I've probably seen more so with family law, and again, it's a different type of breach. But for instance, it comes up a lot in more parenting than I can see property. So parenting agreements when the parents obviously enter into an agreement as to who the children or the child lives with and how much time the children are to spend with the other parent. And it's common that the the children, when spending time with the other parent, that they haven't been provided to the other parent at a certain time. And the primary carer might take it upon themselves to go, look, I'm not going to provide the children to the other parent at this specific time, and leaves no reasons or reasonable excuses to why. Now that's a breach of the agreement. It might be a breach of the order. And there's a number of steps you can take to obviously remedy that breach. And yeah, as again, it happens in every area of law. It can even happen with some people I represent as an accused in criminal matters when an order is made and they're to pay a fine or a bond. That again is a contract with the court that they're going to do something.
Yeah.
And when they don't, it's a breach of contract.
Yeah, look, you can see it in domestic violence cases as well, intervention orders. You
Yeah.
can see it in criminal matters. You can see it in family matters. And, quite often as well, you can have a set of facts, a factual matrix that gives rise to a concurrent criminal and civil matter at the same time. And it doesn't have to be one or the other. Quite often you can have a criminal, one set of facts amount to, for example, a breach of contract, but it might also involve criminal conduct. So you could end up having a criminal matter against one person running at the same time someone's suing them for the same thing. And, generally the criminal matters would preferably run first, but not always. And, this is when you start to see litigation become very complicated when, for example, we'll say police, whether it's federal police, Victoria Police, or some other prosecuting body or regulator, want to pursue the person for the same thing that someone else is privately suing and prosecuting them for. So you can really see that a lot can come out of a breach of contract, and it's not always just as simple as a debt recovery matter or a simple breach. These can give rise to some pretty serious litigation, and I quite often need to be careful when I'm looking at the matter and make sure that the client's got an advocate, a layer of protection by way of legal representation like myself, to make sure that they don't they're no longer speaking for themselves, and they've got that shield to protect them from saying things which may, even if not at that stage, may expose them to broader, for example, criminal liability that they can't see, and there may be some interest from a prosecuting body. So having a lawyer to act as their advocate is a very valuable tool because of the fact that we still have legal professional privilege. So the confidentiality between us and the clients is strong. There's been a lot of attempts to try and get behind legal professional privilege in the past, and I can tell you that the courts uphold that very, very strongly. I haven't seen a big shift towards undermining that at all in my time practicing law, and I don't think we will in the future, but we'll see what the future holds.
Yeah. And the one thing that came to mind during what you've just said, Michael, is prevention is better than cure. So the earlier you can start
Mm.
these processes with a client, the more you can prevent, the quite expensive and
Yeah.
lengthy litigation which can occur if you don't do it correctly. And I can't stress enough when I look at matters, and you've probably had the same thing happen to you when you look at it and go, if only this client saw me a year ago, we could have prevented all this, and we wouldn't be in the situation we are today.
Yeah, mitigating damage, mitigating
Correct.
loss, where possible, is always something that a lawyer should have at the forefront of their mind. It's preventative, as well as trying to remedy something as quickly as possible. But let's turn our mind to what can someone do when there's been a breach identified. We're talking about legal remedies here, and clients are always very interested to know what their rights are and what remedies are available. And I'll outline a few common ones. We look at things under the common law first. Commonly, the first two that I see regularly is things like damages claims for money. And the purpose of damages is to put you in the position you would have been if the contract was honoured. It's not to make you a millionaire, contrary to popular belief. It's to put you in the position you would have been. And another thing we see commonly is restitution. So payment for work done. If the contract was, for example, frustrated or avoided, people are often wanting to be paid. And so, these are common remedies. And then we've got on the other sphere, we've got equity. So when the court draws on its equitable jurisdiction and its powers, there could be broader remedies and maybe filling in the gaps that the common law fails to address. And those are things like specific performance. This means forcing the other party to do what they promised and enforcing the contract and keeping it on foot. It's just a few examples. There's obviously there's a huge body of case law on remedies. So just trying to give some very common examples there.
Yeah. And another one that comes to mind as well is with the criminal jurisdiction, and you touched on this earlier, but
Yeah.
the civil claim is essentially, and if there is a civil claim, is essentially waiting for the result of the criminal matter. So if you're the victim in a criminal matter and you're waiting for the accused to be proven, or the court to prove that what he did or is offending um, has been proven by a court, they wait for that because then that can essentially solidify their civil claim later on. And it's important because when I'm giving advice to criminal clients, I often have to look at this and forecast this to go, look, you might be here, you might just see this as reckless causing serious injury, but you've got to look at the bigger picture.
Well, we alleged criminal
Correct.
clients.
Alleged criminal clients.
Yeah.
You got to always look at the
I
bigger
just
picture.
throw that one in
Yeah,
there.
correct. Now you've always got to look at the bigger picture, and you've always got to say, look, yeah, this is one matter we're looking at, but if you do, your instructions are to plead guilty, then these are the consequences that can stem from that.
It leads into that point. If you look at equitable remedies in the civil jurisdiction, you've got, what would be an example? Criminal restitution matters that flow on from a criminal case, like, for example, maybe under the Sentencing Act in Victoria, or where the prosecution, the police are seeking those as part of financial crime is quite common, and it's. I mean, it may be that it's actually codified in the legislation, for example, in the Sentencing Act, for victims where there's a conviction, so it might be slightly different, but it's still a similar remedy that you see, isn't it?
Yeah, correct. It's a similar remedy, just have different terminology, obviously, for it, which makes it very confusing for a lot of civilians who don't know the law that well. And sometimes, let's face it, Michael, sometimes it is confusing for sometimes some lawyers in different jurisdictions in law because we're not across everything. We know, generally what the law is, but for specific areas, it can be quite specific that we look at it and we think, okay, we've got to research this a bit more. But no, you're right. The remedies are quite similar across the board. Yeah, correct.
You know, like you said, the law is so broad, no one could possibly know everything in the law at all. And it's to try and focus in the areas that you know well and that you're confident in. And, you know, for example, a lot of my practice is in all the different jurisdictions. You know, quite often breach of contract claims will be brought in VCAT, might be for smaller claims like services disputes or residential tenancies, which is still interesting. And that might be, you know, because VCAT being a generally a no cost jurisdiction, meaning everyone's got to bear their own costs. Costs aren't awarded that commonly, although it's possible in some circumstances. Then you might have the magistrates court, yeah, and then you got the magistrates court, which is the next up in the tier from the bottom, and they're for claims up to 100,000, and then beyond that, you've got the county court, you've got the Supreme Court, and they've got unlimited jurisdiction when it comes to monetary claims. And then if you've got federal matters, you might have to go to the Federal Circuit and Family Court of Australia, but the Federal Circuit arm of it, not the family arm. And then you've got the federal court as well. So these claims are brought in different jurisdictions depending on the court's jurisdiction. There is cross-vesting jurisdiction too, so it's not just because it's a federal piece of legislation or that it has to go to the federal courts. It could sometimes be brought in the Supreme Court of Victoria, for an example. And VCAT being, obviously, it's a statutory tribunal, so it's a creature of statute. It can only hear matters that it has jurisdiction given to it to hear. So, you know, the choice of venue when there's a breach of contract is another consideration, but, you know, you need to always have regard to the Civil Procedure Act in Victoria and the overarching purpose and proportionality of the litigation, efficiency, and so we need to be mindful, you know, when we choose the jurisdiction, that we choose the jurisdiction that's going to be not just have the jurisdiction to hear it, but and determine it, but also for the client, you know, to keep their costs down, to find a jurisdiction that's going to deal with the matter as efficiently as possible. If you have the choice between a backlog jurisdiction and one that's more efficient, you might go to the more efficient choice. For example, you know, there may be longer delays in the Supreme Court of Victoria, but the county court's quite efficient. And the magistrates court might be different depending on each venue. It might be Melbourne in the city, it might be one in Heidelberg, it might be Frankston. They may have different workloads. Same with VCAT with different locations. So you really need to consider these things when deciding, you know, where you're going to file your claim if you've got a breach of contract claim.
Yeah. And sometimes in criminal matters, you don't have a choice. And even if it's below the cusp of, say, that $100,000 limit in the magistrates court, I've been involved in matters where it's well and truly under the cusp of $100,000, but they're prosecuted in the county court. And the reason being is because it's the nature of the offending. If it's so serious, then that limit of the $100,000 is no longer relevant. It's the seriousness of the offending. So
Yeah.
yeah, criminal laws may be an exception to the reason other than a civil claim, but yeah, you're right. It pretty much goes to the cutoff point and the quantum of the claim, which is half the battle in dictating, okay, well, which court or tribunal do we go to? And again, if you know what the
Yeah.
backlogs are for each court and jurisdiction, that's handy as well to know.
Yeah, and look, and cases are often
Yeah,
transferred as well between courts, transferred up, transferred down, transferred from a court to a tribunal and vice versa, maybe from a state to a federal or vice versa. So there is legislation to facilitate that, but realistically, you want to try and get the decision right from the beginning. If it's dictated by a counterclaim and that causes a transfer, that's really kind of outside of your control. But generally, choice of jurisdiction is something you want to try and get right the first time at the beginning of the matter, because you don't want to have to incur costs in transferring if possible. And you know, I mean, you know, there's been so many practical scenarios. You know, as coming back to your point, you know, where early intervention, you know, could avoid issues that have subsequently resulted. And you know, I had one case example where a building contractor whose client walked away after 90% of the work was done. We issued a letter of demand. We preserved the evidence, and we got a judgment in under 90 days through the process of just choosing the right court, and in that case it was the county court. But subsequently, the defendant didn't put in a defence or an appearance, and so it was effectively a judgment in default of appearance. That process, and there was a bit of a different process in the county court that needs to be followed with that under the court rules, and you need to look at the practice note. So that was a great example of a situation where there was clearly a breach in the sense that there was non-payment, but achieving a positive outcome because we're moving quickly, and sometimes moving quickly is important, isn't it?
Correct. And an example I'll give is more about early intervention, and it goes back to the case I had between a landlord and a tenant for a commercial lease. And the same example, the tenant was in a 10-year lease, 5 years on one lease and followed by 5 years in another. And it all came down to, once he found out that his bond hadn't been invested in an interest-bearing account, what he needed to do. And it wasn't until he came back to me later on after giving advice and said, if only I got legal advice at the beginning of my second 5-year commercial lease, it would have made a big difference, because the advice I would have given was, it's your duty to make sure that that bond has been invested by the landlord solicitor as per the contract. And you need to calculate, they should give you bank statements. You need to calculate how much that interest is, because if you're on top of it, we wouldn't be having this discussion now on how we're going to get that percentage of, I think it was close to around $40,000 he had to put up as a bond, which had been sitting in a solicitor's trust account, not earning any interest.
Look, hindsight's a beautiful thing. We say it quite frequently, isn't it? You're never going to be able to predict everything, and we're lawyers. We don't have a crystal ball, which I tell clients occasionally, if they ask me too many questions that I can't predict. We can answer a lot. We can't answer everything. We're not magicians, and we don't have a crystal ball. We're not wizards. Some of us are better than others and pay more attention to detail and care more for our clients' interests, like our business does, and yours as well, Alan. But no one's perfect. So, there will be issues that arise, and there's nothing that you can do about some of them except for try and deal with it properly when it arises. And, it gives me thought about a recent matter I had where a client had a loan agreement, he'd lent $300,000 to his friend, and the friend hadn't paid it back, and essentially we went forward and sued once again in the county court. That was defended. We ultimately went to a trial. We were successful. We got costs awarded on an indemnity basis because we put them on notice of costs at the beginning and made a call to bank offer. And we also had interest awarded because the loan agreement provided for a 10% interest, which was reasonable because that's the penalty interest rate. Anyway, and then afterwards we didn't receive payment. So we started to advise the client on enforcement mechanisms. And in that instance, we basically had the order. So we issued a summons for oral examination. And the debtor had to present to court. Were examined on the finances, produced records on his assets, liabilities. Turns out he was earning an enormous amount of money and was on an extremely high-paying job. So we then applied for an attachment of earnings, and effectively that was served on the employer, and we were getting the judgment paid down through that. And in the meantime, we realised that he had a property as well. So we moved down the line of working towards getting the sheriff to seize and sell the property, and then that was lodged on the title. So, and after that was done, he caved. He must have borrowed some money off a family member or something, and our client was paid all the costs, the interest, the judgment amount, and was very happy and pleased. And now that is a fantastic story. That's a best case scenario. They don't all work out as good as that, but it's an example of us utilising the tools available to us. And if it's there, the evidence is there, and we can utilise them, we utilise them. Not everyone's worth going after to a trial. If the person doesn't have any money or assets, maybe sometimes it's not worth pursuing at all. Or you have to stop at some point or try and just settle the case and compromise earlier. But in this case, we had an idea and we had an idea of his asset position early anyway. We'd searched the start of the case and we were just checking later to make sure that they were still there, and they were. So, we were able to enforce that. And that was quite efficient. That was done within 12 months because the 12-month trial set in the county court is quite a common order. I'm not sure if you've got any other final example you want to give anyone.
Yeah, probably a binding financial agreement. I had a gentleman who came to me, and he was quite an older gentleman. He was probably in his late 70s, and he'd entered into a binding financial agreement with his wife during their relationship. However, this was 30 years ago, and if you wind back the clock 30 years ago, he had significant assets at that time. And there was an age gap of about 15 years between them. So she would have been maybe late 20s, early 30s back then. And essentially, the binding financial agreement 30 years ago was to profess my love to you and show you how much this relationship means to me. If we separate, I'll take all the debts, you keep all the assets. They had this binding financial agreement. They started parting ways in his late 70s. And he was just beside himself when he came and saw me, because he was like, well, back then I did this for love. I wasn't thinking, what can I do? And we had to look through this binding financial agreement to see how it would apply, how it wouldn't apply in accordance with the law. Now, there are a number of areas which weren't compliant with the law, one of them being that neither party listed each and every asset, liability, or superannuation at the beginning. So no one truly knew what the asset pool was at the beginning of the relationship. It hadn't been reviewed, as I was saying, regularly, or at least every 2 years. There'd been a significant change of circumstances since that time. So he was no longer working. He had a lot of medical issues. She was working. She was earning a significant amount of income, whereas when they entered into the agreement, she wasn't earning anything. Anyway, long story short was, if that agreement had been enforced and he hadn't seen a lawyer, then he would have walked away just with debts, and the debts would have been probably close to about $200,000, maybe more. Once he saw the lawyer were able to go through everything, we got him a successful result where essentially he got half of what their net asset pool was. Now we're talking about, it's probably close to about $1 million asset pool, so probably got close to about
Yeah,
500,000.
not a
Yeah.
small, not a
No.
small pool yet.
So that was the advantages of seeing a lawyer with respect to the binding financial agreement. Yeah.
Yeah. Yeah, fantastic. And I'm sure you gave that client fantastic representation, Alan, as always. It's been an interesting topic to discuss. Let's just say breach of contract is everywhere. It's in business, relationships, even crime. The key is to know your rights and act early. Don't let emotion or assumptions delay your position. Now, I just want to say to you, Alan, thanks so much for coming on today. It's been fantastic. I would love to have you on at a future time. I hope you've enjoyed yourself.
I have. And if you're unsure whether you have a valid claim or how best to raise or defend one, talk to a lawyer. It can make all the difference.
Yeah, that's right. And, any criminal or family matters as well, I trust that you'll be able to assist anyone with those sorts of matters,
Definitely.
Alan.
Anytime.
Um, and also any commercial, civil, business matters, feel free to reach out to us and visit us at screenilawyers.com.au. Don't forget to subscribe to the YouTube channel as well. It's been fantastic again. We'll be back with another topic soon, so tune in, and thanks for your time and watching.
Thanks, Michael. Thanks for having me.